Welcome. I'm Shirley Malcom, Senior Advisor to the CEO and Director of Sea Change, an institutional transformation initiative of the American Association for the Advancement of Science. I am happy to be here today and to give you a sense of the issues that we try to address within Sea Change. My colleagues today are Jamie Lewis Keith. We've worked together for many years. She brings a background from the university legal side, and Art Coleman. And we've worked together for many years, and Art has been within one of the federal agencies working on a lot of the diversity, equity, and inclusion issues. So let me just turn it over to Jamie for her to introduce herself a little bit more.
Thank you, Shirley, and welcome everyone. I'm Jamie Lewis Keith, a partner at Education Counsel and co leading the higher education practice. Education Counsel is a mission focused education consulting firm that partners with nonprofits and integrates experience in law, policy, strategy, and advocacy to develop and advance evidence based education systems that promote equity, diversity, accountability, quality, and academic freedom and responsibility from early childhood through all levels of higher education, with a particular focus on students, family, and faculty who are not being well served by current systems. I've spent most of my career, as Shirley indicated, inside major private and public research universities, as the first primary inside legal counsel for MIT, and as vice president, general counsel, and university secretary to the board of trustees and president at University of Florida. Over the last 20 years, as I've worked with Shirley and AAAS, we've been working on advancing equity and diversity in STEM fields, including as law and policy advisor to the Sea Change Project, co-leader of the Diversity and the Law Project, and co-originator, law and policy advisor, and executive administrator for the Society's Consortium on Sexual Harassment in STEM. Art?
Good morning, everyone. Hi, Art Coleman. I'm managing partner at Education Counsel. It's a pleasure and a privilege to be with this group today to talk about some important issues on the diversity and equity front. This set of issues has been central to my career almost all of my life. As managing partner at Ed Counsel, I work on higher ed issues with a focus on diversity, equity, inclusion, particularly in the enrollment space and related areas of higher education. As Shirley alluded, I previously served in the Department of Education's Office for Civil Rights as Deputy Assistant Secretary in the mid 90s. Shirley, we're old. And I bring that perspective and experience to the table as well. I am, at the end, a recovering litigator. I was a trial lawyer for a decade before I came to Washington, and I bring that lens to this work as well, along with the passion that I know we all share.
Thank you both. Um, as they indicated, when we work with Sea Change, we have to be attentive to what the legal issues are. While we want to try to transform what happens in colleges and universities so that whatever takes place and whatever the actions are both effective but also legally sustainable in the sense of not violating any kind of the rules of the road. So we need to be able to call on our partners here in from Education Council to provide us with the kind of policy and legal perspective that we need. Most recently, in addition to the work with Sea Change proper, they authored a constellation of 20 diversity, equity, and inclusion resources for policymakers and lawyers. Diversity in the Law 2021. This is funded by the Sloan Foundation and is uh, the kind of the second round of looking at diversity in the law issues. They also facilitated a related course for Sea Change members. Hundreds have linked to the resources. And seven institutions of higher education participated in this 2 year course. Both emphasized what can be done to advance effective diversity, equity, and inclusion policies and actions within the legal framework or design parameters that apply now and whatever the future holds. We're glad to have them here with us today to help us understand the current legal landscape as it relates to diversity, equity, and inclusion in STEM higher education and give us some insight into what might come next from the Supreme Court. Jamie, as I understand it, we can think about this legal landscape for increasing participation of students of color in STEM higher education as a kind of a three-lane highway that has evolved over the last 40 years of decision making by the Supreme Court.
Yes, Shirley, and I'll elaborate. But before we dive into the specifics, I want to lead with the punchline. The most important point that we hope you'll take from this interview is that higher education can do a lot to advance both diversity and equity, regardless of what the Supreme Court decides in two pending cases. It certainly will be consequential if the court imposes any further limitation on race consciousness, but that's not the end of the story. In any event, you do need to know how to advance diversity and equity, and we'll share some key strategies that will bolster the effectiveness and sustainability of an institution's programs under current law, as well as being able to seamlessly position an institution well for whatever happens when the Supreme Court makes its decision. So keep this in mind as we address the challenges and the current legal landscape and forecast the possibilities for the court. Don't be discouraged by this kind of table setting because there are successful navigation strategies. So, as Shirley mentioned, there are over 40 years of Supreme Court rulings that allow consideration of an individual's race and ethnicity when deciding who gets enrollment benefits and opportunities. But there are strict conditions that must be satisfied, and they have gotten stricter over time. Using Shirley's highway analogy, over the last 40 years, we've seen a narrowing of the available lanes that define legally sustainable diversity and equity aims, as well as a tightening of the rules of the road that govern the means, the vehicles that institutions can use to reach their destination and achieve their aims. On our highway, we've got 3 lanes, and allowing consideration of an individual's race or ethnicity in enrollment decision making to remedy the effects of the systemic societal racism that exists in our society on that individual as well as their racial group is the third lane. And that third lane is really the true meaning for affirmative action for racial equity. And it was eliminated in large part by the court in 1978. The second lane, which is allowing consideration of an individual's race or ethnicity to remedy an institution's own intentional discrimination as distinct from societal discrimination, is still open, but it's aging and ill-maintained. This lane has typically been used to remedy an institution's own intentional segregation where there's strong evidence of continuing effects, but it has rarely been used or successful in recent decades. And then Lane 1, allowing limited, holistic, individualized consideration of a person's race or ethnicity in enrollment decision making when necessary to create a broadly, not just racially diverse learning community that benefits all students, is open and has been used by institutions nationwide efforts since 1978. While the cases decided by the Supreme Court over the last 40 years have resulted in some narrowing and potential potholes in Lane 1, institutions can successfully traverse it under current law if they know the rules of the road. But in the Supreme Court's coming 2022 to 2023 term, it will decide an existential challenge to Lane 1's educational diversity justification for individual race consciousness in enrollment.
So, what were the key cases to come through the Supreme Court that created the legal environment that we find ourselves in right now?
Shirley, I'll take that. I think you're making me the historian of the moment, so I'll do my best to capture that history. And that takes us back, I think as Jamie alluded, to 1978 for starters, with the Bakke decision, which held at core that the Equal Protection Clause that applies to public institutions and the Title VI that prohibits race and ethnicity discrimination that applies to private institutions as well as public institutions prohibits differential treatment on the basis of race or ethnicity. In that context, a majority found that remedying general societal discrimination in the way that the Bakke case claimed the University of California at Davis Medical School was doing was unlawful. That they couldn't establish the kind of considerations of race in the admissions process to justify societal discrimination. So that's one of the lanes that Jamie alluded to that is gone as a consequence of that decision. However, Justice Powell, in an important compromise opinion out of that case, found that that bar shouldn't categorically deny all institutions of any consideration of race and opened the door to the consideration of the educational benefits of diversity as a foundation for the limited consideration of race in admissions, as interestingly Harvard was doing at the time and as they advocated in a brief that was filed with the court in that case. Fast forward there then to 1995, where in a non-education case, the U.S. Supreme Court reaffirmed the importance of strict scrutiny on all considerations of race and ethnicity where some benefit was conferred or opportunity was conferred, regardless of the context. In that case, the court said that strict in theory did not necessarily mean fatal in fact, but the court was clear about the rigor associated with this legal standard known as strict scrutiny, which is implicated in all of these cases. Then we get to 2003, and what are really the landmark decisions that set the foundations for the work that institutions have been now doing for decades. Because in those companion cases involving the University of Michigan Law School and undergraduate institution, the court in one fell swoop upheld the law school's holistic review process to advance the educational benefits of diversity while striking down the undergraduate institution's more mechanical consideration of race, a point system in its framework, as being overly mechanical and rigid and not aligned with authentic diversity interests in this nuanced, individualized review that defined holistic review in the admissions process. The major takeaway from this cluster of cases was the court's strong affirmation about the compelling nature of the educational benefits of students, for all students, both in teaching and learning in the classroom, with workforce benefits, with benefits toward civic engagement and leadership, and to support an overall economic and national defense posture. The court went at length to talk about these issues, based in part on amicus briefs that had been filed by Fortune 500 companies and military officials who were affirming the core education principles that the University of Michigan advocated in those cases. At the same time, with that goal setting set in place, the court reaffirmed the parameters around strict scrutiny that tie toward issues of design and operation. One, the emphasis on the consideration of race flexibly as part of holistic review and not mechanically. Two, the ability to actually look for a critical mass and compositional diversity as a foundation for better student experience and learning outcomes. And three, the imperative that schools consider at every step of the way the full array of viable race-neutral strategies that must be explored and pursued where viable as a foundation for any consideration of race in the process. So with Grutter, lane one was clearly paved. Educational diversity is a compelling justification, with guardrails now installed on how the consideration of race might be advanced within an admissions regime. That set the stage for decades of institutional work and reliance on those opinions. The issue would come to the court again in 2013 and 2016 with the Fisher 1 and 2 decisions. In those cases, ultimately, the court upheld UT's holistic review process and applied Grutter's and Bakke's educational diversity interest as controlling law. The court emphasized in a case that was really very much about the underlying evidence that would apply and support a Grutter-like framework that I just articulated. That the educational benefits associated with a diverse student body must be capable of evaluation and capable of being interrogated by a court, and that actual evidence, not just opinion, about the viability and pursuit of race neutral alternatives was an imperative to advance the educational benefits of diversity for all students when you wanted to consider race as part of the process. Importantly, in the UT context, the facts were quite different than in Grutter. In the UT setting, 75% of its class was automatically admitted under the Texas 10% plan. And for the remaining 25%, UT only considered race at one point as part of its holistic review process. It was, in the court's term, a factor of a factor of a factor, so very limited. And that Fisher 2 decision was actually decided in a 4-3 split on the court, with 4 justices rather than the usual 5 or 6 in a tight decision, tied to a recusal and a death on the court. So here we've got a picture of the court as it stood in 2013 into 2016, where we're showing that Justice Scalia did not participate, obviously, in Fisher 2, and Justice Kagan was recused. And so this explains that sort of 4-3 split. But importantly, as we fast forward to 2022, the difference is now we had Justice Kennedy as the conservative swing vote, who voted with Justices Ginsburg, Breyer, and Sotomayor to hold up the UT process. But in 2022, as you have read, Justice Breyer is retiring. Justice Ginsburg passed away in 2021, and so only Justice Sotomayor is left among the justices that upheld UT's process. And the 3 dissenters in that 4-3 decision, who would have struck down UT's race-conscious holistic review process, Chief Justice Roberts, Justice Alito, and Justice Thomas, are now the senior members of a newly constituted and dominant 6-justice conservative wing of the court, with justices whose names are in blue representing Trump appointees from the last presidential term. We obviously now have as well, with Justice Breyer retiring, Judge Ketanji Brown Jackson expected to be confirmed to succeed Justice Breyer. She says she has plans to recuse herself from the Harvard case. I think there is an open question of whether and how that extends to the UNC case, and the broader non-case specific question of whether the court would overrule Bakke and its precedent and progeny in this matter, which is a case that I think Jamie is going to tee up for us.
Tell us a bit more about the cases the court is expected to rule on this year. What are the potential outcomes, and what further narrowing of the road can we expect?
Yes, Shirley. So this newly constituted Supreme Court has agreed to review the Students for Fair Admission versus Harvard and UNC cases, and as Art just said, we will likely only have 2 so-called liberal wing justices represented on the panel. The lower federal courts found in favor of both universities under current law, and in both cases, Students for Fair Admission is now asking the Supreme Court to overrule Bakke and Grutter, strike down educational diversity as a compelling enough interest to ever justify any consideration of an individual's race and ethnicity in higher education admissions. These principles would also affect other enrollment areas such as aid and enrichment programs, even though there may be some slight differences in the way the standards are applied. This would eliminate lane 1. It would eliminate the educational diversity rationale that is being relied upon across the country to enable limited consideration of race in a holistic review. And that would leave only the rarely used and rarely successful lane 2 race-conscious remediation of an individual's own, not society's, segregation or discrimination, with strong evidence of continuing effects and the need for a race-conscious remedy. So 40 years of precedent is what is at stake here, but it's also something that is relied upon across the country, and that's very hard to overrule under the legal standards that apply to whether precedents will be upheld or not. So no one can really predict what the outcome is going to be. While it does seem like very unlikely that this newly constituted Supreme Court would take these cases to maintain the current law exactly as it is, the court could make a narrow, fact based decision upholding current law and finding in favor or against Harvard, UNC, or both of them, based on the application of current law to relatively unique fact dependent aspects of each university's admission process design and practices. If that happens, other institutions would then need to examine some aspects of their own program designs and practices in light of the court's amplification of how to apply current law properly. If the court does not largely maintain the status quo, it could make a decision that broadly affects the institutions all across the country. The court could bar all consideration of individuals' racial status in admissions decision making, which would also affect other enrollment programs, or it could permit only the more constrained consideration of race under federal law as interpreted in the University of Texas model that the court described in Fisher with those kinds of facts. Or it could impose significant new conditions that are even stricter and more difficult to satisfy than current law, making it correspondingly more difficult to consider race of individuals in the enrollment programs. The court could hold oral arguments as early as the fall of 2022 and will in all likelihood make a decision no later than the end of June of 2023. So in about a year, we're going to know the answer. But while any loss or even greater limits on race consciousness would have a consequential effect, there are actions that your institutions can take to advance diversity and equity aims regardless of what the court's decision is. Federal non-discrimination law does not generally regulate race and ethnicity as a subject matter, and it doesn't generally regulate diversity and equity aims alone. There's room to move within that space, and we'll be elevating important strategies for doing so in the second part of this interview, so tune in.
Thank you, Jamie. We are looking forward to the next session where we do talk about what we can do. There may be some of you who are out there who wonder why AAAS would be having this kind of a conversation. One of our major goals, one of our major missions as an organization is to diversify the science and engineering workforce and to strengthen the science and engineering workforce. We can only do that by the way that we educate and the way that we prepare students, and how we are able to accomplish that matters. And so we really need to understand what the rules of the road are and how we can go about, especially through initiatives such as Sea Change, to actually accomplish this. So stay tuned. We look forward to session 2.